Hello to my contracts law class. We are in week 5. It's hard to believe that we only have this week and next week left of the summer session course in law of contracts, and that we will be taking our final exam next week. All right, so you were assigned last week to read chapter 16, which is about the writing requirement and most importantly the statute of frauds. So I'd like to pick out a few things from chapter 16 that are extremely important, and go over a few things just to highlight them. Also, I want you to know we are skipping chapter 17. I incorporate the information in chapter 17 throughout the semester, so we skip that one. We will be doing 18 and 19, and that will be it. And you will have your final based on everything since the last exam. So let's look at chapter 16, the writing requirement. Chapter 16 deals with the statute of frauds. The statute of frauds has been around for hundreds of years, created at common law. And the statute of frauds requires that certain types of contracts must be in writing to be enforceable. If they are not in writing, you should assume if it's required. And what do I mean by required? The statute of frauds, meaning that a law is passed that specifically states the types of contracts that must be in writing, or the court's first reaction will be they are unenforceable. If you look in chapter 16, it gives us a list of, generally speaking, the kinds of contracts that most states require be in writing. Now, I want you to notice that it refers to a written memorandum. It does not mean that you have to have a 10-page formally written contract, but it does mean in these types of contracts, the courts want to see evidence of a writing that tells them the most important information so that they can enforce a contract, who the parties are, what the agreement is, the purpose of the contract, the bargained for and legally sufficient consideration, and that the parties themselves have capacity, have legal capacity to enter into a contract. All those things will be evidenced by some kind of writing. And if the law doesn't require a specific form, which under the statute of frauds it usually doesn't in most cases, it will require that the court see a written instrument of some kind that they can discern what the agreement was, who the parties are, what the consideration is, to be able to enforce it. All right, contracts that require a writing. Contracts involving an interest in land. If you're going to sell land or you're buying land, that agreement better be in writing, or the courts are not going to enforce it most of the time. 2, contracts that cannot be, by the term of their contract, performed within 1 year from the day after the date of signing of formation. Collateral or secondary contracts, such as promises that someone will pay for the debt or a duty of someone else, they must be in writing. 4, promises made in consideration of marriage. And 5, under the UCC, Uniform Commercial Code, contracts for the sale of goods that are at least $500 or more. Okay, most of the time we study the statute of frauds as it relates to contracts involving an interest in land, because to enforce those types of contracts, courts want to know what the parties agreed to. If they can't determine it, and if there is no written document, chances are they are not going to enforce your contract for some kind of an interest in land. The chapter then talks about the year rule, that you look at the terms of the contract, and if it cannot be performed from within 1 year from the day after it's signed. It must be in writing to enforce it. It talks about collateral promises or secondary promises. It talks about promises made in consideration of marriage. And then, of course, what we see all the time in the law is that we are told there are certain rules and laws, like the statute of frauds and the requirement of a written document, or it won't be enforceable. And then we are given the exceptions to the writing requirement. What happens when a case comes before the court and the parties say, or at least one party says, that they had a contract, but it was not written, it was oral? And we know under the statute of frauds, if it's one of those types of contracts that require a writing as evidence that the contract exists and is enforceable, that the courts are usually not going to enforce it. But as usual with the law, there are some exceptions. One exception that they talk about is partial performance. And they say when a court looks at a contract that should have been in writing but wasn't in writing, but it's been partially performed, and the parties cannot be returned to the position they were in before the contract was formed, the court will sometimes grant what is called specific performance. Specific performance is where a court orders parties to a contract to do what they had agreed upon in the contract. Now, courts don't like to order specific performance. Think about this. There's this amazing portrait painter, and you hire this painter and you pay a lot of money to this painter, and that painter is going to come and they're going to paint portraits of your children. And just before they are going to do that, they call and they say, I have a really big job and I'm not going to be able to do this for you. And so I'm going to have to get out of our contract. And you don't want them to get out of the contract. You want them to abide by the terms of the contract. You want them to paint your children's portraits. Generally speaking, if that were something that had to be in writing and it was not in writing, then sometimes a party will go into court and will ask the court for specific performance, to order that painter to paint those portraits. But the reason the court doesn't like to do that is because when they order someone to actually do something, not just to pay damages to the person who they have breached an agreement with, but to carry out what they agreed, usually it ends up with a bigger lawsuit after that. Because what will probably happen if they specifically performed is that the picture of the children, the portrait, is not going to be up to their standards, and then there'll be another lawsuit. However, when it comes to the sale of land, it is believed, and it is true, that every single piece of land on earth is unique. There are no two exactly the same. Even though sometimes they may look the same, they may be next to each other, they are not exactly the same. Courts will often, in a purchase and sale agreement, some kind of an agreement for the sale of land, will order specific performance where one party is breaching the contract. But in all other aspects, even partial performance, although they may do it, it is an equitable remedy, something other than money. You always risk that ordering someone to do something that they no longer wish to do will mean that they don't perform it up to the standard that they would have. Okay. I want to talk about promissory estoppel. We talked about it, we learned about it in earlier chapters, but promissory estoppel plays a part here in the statute of frauds and the enforcement of a contract that one party brings before the court saying that the other party has breached it. And it says an oral contract that would otherwise require it be written under the statute of frauds may be enforced in some states by some courts, depending on the circumstances, under the doctrine of promissory estoppel. Now, just to refresh your recollection, you should know promissory estoppel by now, but that one person agrees to do something and the other person justifiably relies on that and takes action to their detriment. The person who is breaching the contract cannot get out of the contract. The court will order them, because of the reliance, to either pay damages or to specifically perform. And it says, for the promise to be enforceable, the promisee must have justifiably relied on the promise made to them by their detriment, and the reliance must have been foreseeable to the person making the promise. In addition, there may be no way to avoid an injustice in the court's belief other than enforcing what the agreement was, even though the law under the statute of frauds had wanted it to be in writing. So courts will look at the cases and the circumstances and the requirements of what should be in there and decide what they think is the just decision in a case like that. And sometimes, even where the statute of frauds requires something to be in writing, under that equitable doctrine, that fairness, and so that someone isn't unjustly enriched, may use promissory estoppel to enforce a contract that wouldn't be enforceable otherwise because it did not comply with the writing requirement of the statute of frauds. The chapter then talks about, so what does it mean to be a writing? And I just addressed this, that when we say the statute of frauds requires these types of contracts to be in writing, it doesn't necessarily mean that it must be some big formal contract. It can be, but most of the time it just requires that all the elements of the contract, all the important elements, are there in some form of a memorandum, emails, text, anything like that, that the court can put together, be able to determine the agreement, what it was, who the parties are, what the consideration was, and that will often be sufficient to comply with the statute of frauds requirement that it be a writing. The last thing I just want to talk about here is the parole evidence rule. So here's the thing, when a contract is written, there is usually a clause in that contract that says something to the effect that this contract is the only evidence of the final and complete agreement between the parties. The court assumes that if you have a contract, it is the complete agreement of the parties. And even most contracts, good contracts, will have a clause that says if the parties agree to in any way change, enhance, add, take away from anything in this contract, then that agreement must also be in writing, signed by the parties. Okay? The parole evidence rule is a situation where one party or the other wants to get up and testify that even though there was a written contract, the parties had agreed to something else. And the parole evidence rule says that if a contract is in writing and it looks to be the evidence of the final agreement and complete agreement between the parties, the courts won't allow someone to testify, a party to testify, that they agreed to something else. If you agree to something else, it also needs to be in writing to be enforceable. Now again, that's the rule, but we also know that there are sometimes exceptions where the courts will make an exception and allow parole evidence, allow one or both of the parties to testify that yes, that was the original, but we changed it, but we didn't comply with the writing requirement with the changes. And so you can see in your book near the end of the chapter under the parole evidence rule, exceptions to the parole evidence rule, contracts subsequently modified, and it talks about what types, void or voidable contracts, contracts containing ambiguous terms, incomplete contracts, all of these. But remember, under the parole evidence rule, if a court finds that a written contract represents the complete and final agreement of the parties, it is not going to allow oral evidence of something else to come in unless it believes it falls under one of the exceptions. I've said this since the beginning. I say it in all of my contracts classes. When you enter into a contract, whether it is an oral or a written contract, you should assume you will be held to the terms of those contracts. And as a lawyer, I also always say, no matter what the subject matter is of that contract, I always believe that to protect the parties, to protect yourself, you should get it in writing. Whether that's on a napkin, whether that's through emails and texts, whatever it is, to have evidence of who the parties are, what the agreement was, what the consideration was, and the purpose of the contract. So a court can sort of cobble and piece together all of that written information to form the contract and to also enforce that contract. So be sure when you read chapter 16 that you carefully understand all those concepts that we're talking about here. And then you're going to skip 17 and go on to chapter 18 this week, performance and discharge. Full performance of the contract, an executed contract where all parties have done everything they're supposed to and the contract ends, as opposed to having to go to court because someone has breached the contract. Chapter 18 is going to talk about conditions and performance and discharge. And then the last chapter we will be looking at this semester is chapter 19. It's something that we've been talking about since the very beginning of this course, but it goes into specifics on damages, remedies, and breach of contract. One thing about studying contracts is that when we study cases, they are all cases where something has gone wrong, and we end up in the courts and we learn how the courts have interpreted the law and the contracts themselves between parties. And so, although 19 is an important chapter and a lot of information that you could see on an exam, we've been talking about breach of contract and remedies since the first week of this course. All right, so we are going to be reading 18 and 19 this week. I'll be sending you my notes for chapter 16 and this week and next week, and then our summer session law of contracts will come to an end. As of now, your final exam, I'm planning on sending you a week from today, next Tuesday, and you will have 2 days. It'll have to be handed in sent in on Thursday, and you need to make sure that gets to me on time because we have a very short period of time to get in grades for the summer session. So you cannot hand in those final exams late. Okay, that's it. Welcome to week 5. We are getting to the end of this chapter and this course and completing the course on law of contracts. Have a great week. See you next week.